up here. The NAACP Legal Defense Fund was founded in 1940. And in 1940, our jurisprudence condoned overt racial discrimination premised on white supremacy. It's a very harsh reality that we dismiss as though it's just a fantasy. There were laws that actually required discrimination against black people and other minorities, and those laws were upheld by very revered justices of our Supreme Court, including Justice Oliver Wendell Holmes, notwithstanding the 14th and 15th Amendments. Those Supreme Court opinions are not any longer included in most of our con law case books, and they're not discussed in law schools, in part because they are simply too embarrassing and too indefensible in today's reality. LDF was formed to challenge that older jurisprudence and to replace it with a jurisprudence that I explain by saying it's predicated on democracy, predicated on inclusion, and actually predicated on a sense of justice that comes from those first two. Now, we've come a very long way from that older jurisprudence. The concept of law as neutral and judges as umpires, I believe, comes out of that earlier period that was there to justify the decisions that I say today are embarrassing and indefensible. In something that Stanley wrote on the New York Times about this topic, empathy, a couple of weeks ago, he put this in this same context, I think, that there were very respected scholars, academics, who talked about neutrality as the guiding principle of how law ought to work, what Dahlia was talking about from Justice Holmes. A lot of people in here know who Herbert Wechsler was. He wrote one of the most influential law review pieces, I would say, ever, toward neutral principles of understanding, toward neutral principles of constitutional law. It was published in 1959 in the Harvard Law Review. It was a lecture first, and actually it's a lecture that came right after a similar lecture by Learned Hand. In his law review, Toward Neutral Principles, Herbert Wechsler talks about and reviews a number of cases, but he gives very special attention to three of LDF's most famous cases. Smith versus Allwright, the case in which the Supreme Court found that the all-white primary was unconstitutional. Shelley versus Kramer, which found that racially segregated housing was unconstitutional, and Brown versus Board of Education, which found that racially segregated public education was unconstitutional. Wechsler was, he said in the article, sympathetic to the outcomes in all three cases, but he lamented could find no neutral principle that would justify any of those decisions. Now you really have to ponder that, okay? Wechsler claimed there was no constitutional principle that justified the outcomes in those cases. Cases, again, would have relegated black people to the margins of our society by allowing them to be essentially disenfranchised, would have put them outside of political life, would have relegated them outside of better housing, and confined them to inferior schools. Wechsler said that was simply beyond constitutional challenge. It's a harrowing concept of a democracy. Okay, if a democracy is supposed to be we the people and everybody's in, then the idea that the majority could in fact exclude some of the people from it, I find it harrowing. This is Herbert Wechsler. I'm going to read you two little things from Toward Neutral Principles of Constitutional Law. Most people have not read that article. They have read a little excerpt in their con law case book, okay? And if you read the paragraphs where he gets to the core of the point, it's on the next to last page, and he makes a reference in it that you're going to hear to Charles H. Houston, who, if you don't know, is the founder of LDF and maybe one of the greatest legal minds of the 20th century. The road to Brown is his blueprint, okay? That's who gets us to Brown. This is Herbert Wechsler, commenting on the three cases I just described. For me, assuming equal facilities, the question posed by state-enforced segregation is not one of discrimination at all. Its human and its constitutional dimensions lie entirely elsewhere, in the denial by the state of freedom to associate, a denial that impinges in the same way on any groups or races that may be involved. I think, and I hope not without foundation, that the Southern white also pays heavily for segregation, not only in the sense of guilt that he must carry, but also in the benefits he is denied. In the days when I was joined with Charles H. Houston in a litigation in the Supreme Court, before the present building was constructed, I'm going to stop. That means before 1935, that's when the Supreme Court building was constructed. And we know, I know, that the litigation he's talking about was when Charles Houston had a case in the Supreme Court and he, Herbert Wechsler, was a clerk, okay? He invited Charles Houston to have lunch in the Capitol where the Supreme Court sat, and the Capitol dining room was for white people only. There's no separate dining hall. Okay? In the days when I was joined with Charles H. Houston in a litigation in the Supreme Court, before the present building was constructed, he did not suffer more than I in knowing that we had to go to Union Station to lunch together during recess. But if the freedom of association is denied by segregation, integration forces an association upon those for whom it is unpleasant or repugnant. Given a situation where the state must practically choose between denying the association to those individuals who wish it or imposing it on those who would avoid it, is there a basis in neutral principles for holding that the Constitution demands that the claims for association should prevail? I should like to think there is, but I confess that I have not yet written the opinion. To write it is for me the challenge of the school segregation cases. He couldn't find a neutral principle. LDF's view is far different. In our view, constitutional jurisprudence has to conform to the demands of our democracy. Democracy should have as its guiding principle democracy confidently embraced. Brown clearly saw democracy as a value that animated the decision. It says so, okay? As for umpires, I'm not really sure what that's supposed to connote. I know we all like to laugh about that reference. I'm not sure what it's really supposed to be connoting. It sounds like a view that judges should have no interest in the democracy they would play an important role in, almost a view that they should be strangers to our democracy and to our society. It's a bizarre view. In Grutter, the Michigan affirmative action cases, my cases, I argued them. In Grutter, Justice O'Connor certainly was not advocating neutrality. This is the sentence that I think sums up what Grutter is about, and it certainly sums up what I argued. This is Justice O'Connor in Grutter. Nothing less than the nation's future depends upon leaders trained through wide exposure to the ideas and mores of students as diverse as this nation of many peoples. That's clearly about democracy, and it's about the requirements of inclusion. I believe that judges and justices of the Supreme Court also benefit from that wide exposure that she's talking about, and that they are in fact better judges and better justices for that wide exposure to the ideas and mores of people as diverse as this nation has. The Wechsler sense of neutrality is the antithesis of that concept of exposure. He, in the sentence I read, and the little section I read, seems literally proud of his own insularity and arrogant in his assumption that he doesn't even have to know or inquire if Charles Houston or anybody else had a different view of what the issues were. It's kind of breathtaking. In the days when I was joined with Charles H. Houston in a litigation in the Supreme Court, before the present building was constructed, he did not suffer more than I in knowing that we had to go to